The Human Rights Clinic provides free legal support for people who are making complaints to the BC Human Rights Tribunal about discrimination. And I'm going to tell you all about that. Complaints, Human Rights Tribunal, discrimination, throughout the course of these workshops. But our clinic just works on sort of one side of the equation. We only represent people who are making a complaint that they have experienced discrimination. Sara at Forte Law works with people on both sides of the equation. So she may represent someone who has experienced discrimination and is making a human rights complaint, but she also helps work with employers and others who have had a complaint made against them. And she will help them to navigate that process as well. So we bring different perspectives and different experiences to this workshop. And I hope that helps us give a good balanced presentation. I might have a perspective that's more towards the side of complainants, and she's really good at balancing that by reminding us about what employers can do and should do and need to do around some of these issues. So the Human Rights Clinic is part of CLASS. You see the CLASS logo there. CLASS stands for Community Legal Assistance Society. And we're a nonprofit legal organization based in Vancouver that provides free legal services to people with a whole range of legal issues, including tenancy issues, issues in their housing, issues in the workplace, debt problems, workers' rights, just a whole range of different things, mental health law, as well as human rights. So the clinic is one part of CLASS, and what the Human Rights Clinic does is work specifically on human rights and discrimination issues, the things that we're going to be talking about today and for the next 3 sessions after this. Our services are free, and we provide a range of different kinds of services, from meeting with someone for a half an hour and talking to them about their issue and giving them some advice about what they might do next, all the way to acting as someone's lawyer and representing them at a hearing of their human rights complaint. We're a nonprofit. We get our funding from the provincial government, from the Ministry of the Attorney General. And like all nonprofits, we don't have enough resources to do everything that we want to do or help everyone that needs our assistance. But we do try to help as many people as possible with at least some service. So that's why we offer that range of services, from a half an hour to maybe a couple hours, all the way up to fully representing someone all the way through the process. We have a clinic that we run on Mondays in downtown Vancouver, where anyone can come and get, as I mentioned, a half an hour of free legal advice and information. Usually that clinic operates at the Human Rights Tribunal, but right now we're in a different space. But we've got a website. In fact, that's the top bar of the website that I just snipped out and put up there. So if it might be helpful to you at any point to have a half an hour consultation with a lawyer or a legal advocate about a potential human rights issue, you can go to our website. If you search BC Human Rights Clinic, you'll find it, no problem. And you can make an appointment for one of those half-hour slots to just check in with somebody about something that might be going on for you. And then the other thing we do is education workshops. So I get to come and meet with groups like this. I also sometimes meet with employers, human resources professionals, landlords, other service providers to help people understand their rights under human rights law, and also to help people like employers and others understand their obligations, their responsibilities to protect people's human rights who are working for them or who are living in their apartment buildings and so forth. Mm-hmm. So I think I have the best job because I get to represent people and give people legal advice about their specific problems, but I also get to get out of the office and come and meet with folks like you. So I'm really glad to be here and glad to have a chance to give you a bit more information about the Human Rights Clinic. So today's session is really going to be an introduction and an overview to the content and what we're talking about in these workshops. And then Part 2 and Part 3 will get into some of the real nuts and bolts of human rights and how it applies to mental illness, mental health challenges, and other disabilities in particular. And we'll also spend some time covering the nuts and bolts of actually making a human rights complaint. What does that look like? How do you do it? How long does it take? Where do you go for help? And those kinds of things. So that's the general overview for the 4 sessions. But what I'd like to talk about is what human rights even are. What are we talking about when we talk about human rights? Where do they come from? And how are they protected? Where in the law are our human rights protected? One of the places that they're protected is in the BC Human Rights Code. So we'll talk about the code and we'll talk about the Tribunal, which helps us enforce our rights under the BC Human Rights Code. And then we'll introduce some key concepts, including direct discrimination, indirect, which is also known as adverse effect discrimination. We'll talk a bit about the concept of intersectionality, and we'll talk about accommodation. What does it mean to provide an accommodation for someone? As I mentioned, the first thing that I wanted to talk about is what even are human rights? What are we talking about when we talk about human rights? And I like to kind of start here by putting it to all of you. When you hear the words human rights, what comes to mind for you? What does that mean for you in your everyday life or your experience? Would anyone like to share? What are human rights? I can tell that you have something to say.
It's not like everyday something I learned, like a fundamental and protected rights.
Fundamental protected rights. Fantastic. That word fundamental is really, really key. Can anyone add or expand on that?
Basic rights that everyone has.
Basic, fundamental rights that everyone has. By virtue of being human, you have these basic, fundamental human rights. Fantastic. What are some examples of human rights? What are some of these basic, fundamental rights that we have just by virtue of the fact that we are human beings? Yeah.
Speech.
The right to freedom of speech, freedom of expression. That's an important one. Thank you. What else? What do you think, Carrie?
Like not being discriminated against and maybe open that to other people on what grounds.
Thank you. So the right not to be discriminated against, not to be treated differently based on something that Carrie just alluded to, different grounds of discrimination. I really like that the right to an education came up, and maybe others were thinking about things along those same lines. The right to housing we hear about a lot, in the Lower Mainland especially maybe, given how many people don't have access to their right to housing. The right to an education, the right to food, the right to an adequate standard of living. These are human rights, but not human rights that we've done a very good job actually protecting in Canada. As I mentioned, and as you all know, we have lots of people living homeless right in our own city. So the right to an education or the right to housing are good examples of rights that are what we think of as international human rights. And they exist way up here. They're sort of big picture human rights that we believe in, that we aspire to, but that don't always find strong legal protections in our own countries and communities. Things like the right to education, the right to an adequate standard of living are protected in international human rights agreements, but those agreements are not always directly enforceable here in Canada. So I think it's really important to remember that human rights kind of capture that big picture. But when we want to talk about our legal human rights, the things that you and I here in the Lower Mainland can actually make meaningful in our own lives, we have to go a little bit deeper. I sometimes think of it as a funnel. We've got international human rights law up here, but to get a little closer to home, a little more meaningful, we have to filter in a little bit. And when we do that, we filter in and get to the Canadian Charter of Rights and Freedoms. Who's heard of the Charter of Rights and Freedoms? Yeah. What can you tell me about the Charter of Rights and Freedoms? What do you know about it? Yeah.
Not every right is absolute and perfect.
Oh, great. Not every right is absolute. That's right. The very first section of the Charter tells us that rights have to be balanced and that some rights are limited for good reasons sometimes. We don't allow, you gave the example of freedom of speech. Freedom of speech is a really important right, but it can be limited in certain appropriate situations. For example, prohibitions on hate speech. We don't allow people to say hateful and discriminatory things or incite other people to violence or make threats against people or defame people. There are reasonable limits on our right to freedom of expression. So that's a fantastic introduction to the Charter. Thank you. Anything else you can tell me about the Charter? Charter of Rights and Freedoms? Yeah.
It's only really applied in things like government or government bodies.
Fantastic. I didn't learn that until I went to law school. Did everybody catch that? The Charter actually only applies to the government and to government actors. An example of a government actor would be the police, for example. The Charter applies to things the government does. For example, making laws. So any law that the government passes has to comply with the Charter. And any actions that state actors, government actors make, like the police, also has to comply with the Charter. And the Charter protects things like your right to be free from unreasonable searches or detentions by the police. Those are really important rights. It also protects the right to be free from discrimination, protects freedom of expression, of association, of religion, protects our right to vote. Whole range of different rights are protected by the Charter of Rights and Freedoms. But because it only applies to government, it again isn't super accessible for regular people. It's certainly true that regular people sometimes do use the Charter to enforce their rights. For example, rights against arbitrary detentions by the police. Somebody might use the Charter to defend their rights, or if somebody's experiencing discriminatory treatment by a hospital, for example, which is kind of government-y, and you can use the Charter. That might be a place where the Charter would come into play, but for most of us, our day-to-day lives, we're interacting with the government sometimes, but more often we have private interactions with employers, with landlords, with service providers, with our unions or professional associations, and the Charter doesn't apply in those spaces. So we need, to our next slide, to go one level closer to our everyday experience and come to human rights legislation. And that's what the rest of these workshops is really going to be about. Specifically, the right-hand side of the slide here, the BC Human Rights Code. I'll just say a bit about the Canadian Human Rights Code and the Act and the difference between the two. As you may know, Canada has this very complicated structure where some things are under the authority of the federal government in Ottawa, and some things are under the authority of the provincial government. For BC, that would be in Victoria. And for things that are under the authority of the federal government, that would include things like banks, telecommunications, airlines, First Nations governments, trucking companies, things that cross borders, generally, the railway. If people experience a human rights problem in one of those areas, they are protected by the Canadian Human Rights Act, and they would make a complaint about discrimination to the Canadian Human Rights Commission. So let's say you worked for Air Canada and you were being sexually harassed on the job. You could make a complaint to the Canadian Human Rights Commission. However, if you worked for the Surrey McDonald's and you are experiencing sexual harassment or some other form of discrimination, your complaint would fall over here under the BC Human Rights Code, because a business like McDonald's is under provincial authority. And most areas of our lives, our homes, for most of us, our jobs, the services that we access, most of them are going to fall under provincial authority. So for the rest of these workshops, I'm going to be talking about the BC Human Rights Code and the BC Tribunal. I just wanted to flag that there also is this other federal system. Any questions so far? Yeah?
I was wondering, didn't really understand, what are universities or schools, right? The federal, right?
No, universities are under provincial authority. Yep. So people do make complaints against their universities to the Human Rights Tribunal, the Provincial Human Rights Tribunal.
So it was,
The right side. Sorry. Yeah. Yeah. Universities are provincial and would fall under the right side of the equation here. So the BC Human Rights Code is what applies in BC. And every province has a similar law. Some of them are called human rights codes. Some of them are called Human Rights Act. I think in Quebec it's called a Human Rights Charter. They might have different names, but they're all pretty similar. They protect similar kinds of things. And what those things in general are protections from discrimination in different areas of our lives. Here in BC, the code covers employment, tenancy, and services that are provided within the province. Universities would be examples of service providers. And so all of those areas, in all of those areas, we are protected from discrimination. The Human Rights Code gives us a direct access approach to making human rights complaints, which means that just like a lawsuit in court or a complaint under the Employment Standards Branch, you simply file your complaint directly to the Human Rights Tribunal. There's no investigation that happens first. In some provinces, and in the federal system, there's a commission that acts as a sort of gatekeeper that investigates complaints before they go to the tribunal for resolution. We don't have that in BC. Our rights are directly enforced by the BC Human Rights Tribunal. And if you believe you've experienced discrimination in one of those areas, employment, tenancy, or services, you are able to make a complaint directly to the tribunal. Thanks, Denzel. And the BC Human Rights Tribunal is what we call an administrative tribunal. You can think of it generally as a court. It's not technically a court, but it's very much like a court. So for our purposes, we can just think of it as court-like. And just like a court, it hears and decides complaints that are brought before it. The decision makers are independent and like judges, not like that guy, they don't look like that too often, but they will hear a case, hear both sides of the case, and make a decision about whether they agree that the complainant who brought the case forward experienced discrimination. And if they agree that discrimination did happen, they have the power to order compensation and other forms of what are called remedies for the discrimination. And I'll talk more about that in a little bit. One great thing about the Human Rights Tribunal is that it's free to access. Anyone can go on the Human Rights Tribunal website, download the complaint form, or even fill it out online, send it in, and start a human rights complaint for free. There's no filing fee, there's no money barrier to accessing the tribunal's services. Whereas in court, it can cost a lot of money even to just start a complaint, much less get a lawyer and proceed all the way through the process. Another great thing from my perspective about the Human Rights Tribunal is that it offers free mediation services. A mediation is an opportunity to see if the complainant and the person they've made the complaint about, or the business they've made the complaint about, which is called the respondent, and responding to the complaint, the tribunal will see if it can bring the parties together for a mediation to resolve the complaint without the need for it to go to a more formal hearing and decision. And oftentimes, the parties are able to have a negotiation and come to a settlement where they agree that they will resolve the complaint for usually some compensation and maybe some changes by the respondent. Changes to their practices or policies, for example. And another thing that I think is good about the tribunal and that helps make it accessible to regular people is the fact that it very rarely awards costs against an unsuccessful person or party. So even if you believe you've been discriminated against, you make a human rights complaint and you lose. For whatever reason, you weren't able to prove that you had been discriminated against and you're not successful in your claim. The Human Rights Tribunal says, okay, you lost your complaint, but there's no penalty for bringing it forward. There's no money that you have to pay to the other side because you made an unsuccessful human rights complaint against them. Whereas sometimes in other court proceedings, that is a consequence of losing your case. If you sue somebody and are unsuccessful in your lawsuit, you may be on the hook for their legal fees, which can be pretty scary and pretty expensive, and in my experience, it deters people from bringing cases forward to court. The Human Rights Tribunal doesn't do that. It says as long as you are complying with the rules and you bring a complaint forward in good faith, believing that you've really experienced discrimination, but you're just not able to prove it and you're not successful, I'm not going to punish you for doing that. Everyone should be able to assert their rights and seek a remedy. And just because they're not successful in meeting the legal standard for proving their claim doesn't mean that they should be punished with costs. There's one other point that I wanted to make about the Human Rights Tribunal really early in our time together because it's so important, which is that there is a 1-year deadline for filing a human rights complaint. You have 1 year from the date that the thing that you believe was discriminatory happened to you to file your complaint. That's a new time limit. It used to be 6 months, and in fact, I think when I did this workshop last time, the deadline was 6 months. So in the fall, it was changed. A new law, an amendment was passed, extending the deadline to a year, which I think is really good. 6 months is pretty fast to sort of gather all of your documents, get the advice and help that you need, and file a complaint. I think 1 year is a much more reasonable time frame. So we're glad to see that change. Does anyone have any questions here about this kind of overview of the Human Rights Tribunal, what it is, what it does, how it works, anything like that? Okay, great. The Human Rights Tribunal's website is a really useful resource as well. It has lots of information about discrimination and the protections that the Human Rights Code provides, as well as how the complaint process works. So anything that you want to confirm or sort of look up more information about from this presentation, you'll probably find that information on the Human Rights Tribunal website if you go. I want to switch gears now from talking about the tribunal, which is the court-like body that enforces people's human rights, and to talk about the law itself, which is the Human Rights Code. The BC Human Rights Code is the name of the law and protects us from discrimination, again, in our jobs, in our tenancies, and in our access to services. And I'd like to start with this section of the code. It's one of the very first sections. I think it's number 3 in the code, right after they say what the name of the law is. So right up front, the purposes of the code. Why do we have anti-discrimination laws, human rights laws at all? What is the point of this code? What is it trying to achieve for our society and for the people that live here? And I know it's a lot of text. I won't read it all out to you, But there are a couple that I really like, and A, I think is a really great one. Fostering a society in which there are no impediments to full and free participation in the economic, social, political, and cultural life of British Columbia. And when we're talking about people with disabilities and discrimination on the basis of disabilities, this is a really key purpose, right? Ensuring there are no barriers to everyone's ability to participate in the world, in jobs, in access to services, and so forth. I think B is nice as well, to promote a climate of understanding and mutual respect, where all are equal in dignity and rights. Climate of understanding and mutual respect. That sounds pretty good to me. I feel often we could use a little bit more of that. And I think D is important to emphasize as well, to identify and eliminate persistent patterns of inequality associated with discrimination prohibited by the code. That really speaks to the kinds of systemic discrimination that exist in BC and in Canada and throughout the world. And the code, yes, is about giving people the opportunity to make complaints about and get redress for things that have happened to them personally, but it's also about trying to address these larger patterns of inequality and discrimination within society. And it has a preventative role as well, to try to undo these barriers and get rid of these injustices or unfairnesses in the world. So it's a pretty ambitious set of purposes, lofty goals, but I think it's important to remember that the code doesn't just exist to allow people to make complaints against their employer, but it also allows us to step back and look more generally at inequalities or unfairness that may exist in access to employment more generally. So I've used this word a lot already, discrimination. And I'd like to throw it back to you for a few minutes to just reflect on what this word means to you. And I'd just like to invite you to share. When you hear the word discrimination, what comes up for you? What does that make you think? What does discrimination mean to you?
That makes me think of bullying.
Bullying. Yeah. Bullying someone, treating them badly, harshly. Yeah. Okay, great. Thank you. What else?
When somebody can't access something based on something that affects their life, such as a disability or gender or sexuality.
Great. So a lack of access, or not a lack, I shouldn't say, but a barrier to access because of something about oneself that's part of who they are. Great. When I think of discrimination, I also think of bullying, I think of harassment, name calling, absolutely. I think of singling someone out and treating them badly and differently. And as Carrie said, because of who they are, because of some personal characteristic or set of characteristics that they may not have any control over. Discrimination might look like applying stereotypes to people. Who knows what a stereotype is? What is a stereotype, Spring?
It's where you label us all with one thing.
Yeah, labeling a whole group of people with one
For
thing.
example, like I'm native, so as they say, right? I often hear, all natives are drunks. No, we're not.
Of course
But
not.
we've now taken that whole stereotype and, ran it over
Yeah.
wherever, right?
Yeah, absolutely. So we can think of stereotypes that we've heard about Indigenous people, about people with disabilities. I have 2 teenagers at home. I think about the stereotypes around teenagers, for example. They're lazy, or they're entitled, and sure, some of them might be. And some of them are incredibly hardworking and doing great stuff for their communities. So painting everyone with the same brush is a great definition of stereotypes and not acknowledging people's individuality. Biases, kind of same idea. If we're biased against a particular group of people based on stereotypes that we may hold about them, if we believe that all teenagers are lazy, we're probably not going to hire them for work, for example. I think about excluding people and punishing people. And then we might also think about these larger patterns, as Carrie was getting at, these big systemic barriers that people may experience because of who they are, because of personal characteristics that they may hold. So we're going to talk more in depth about these different kinds of discrimination. In human rights law, we talk about two broad categories of discrimination. The first is direct discrimination. And that's, I think, the kind that we are most familiar with. It's the kind that really smacks us across the face and you sort of can't deny that what's just happened was discriminatory because it's so direct and so obvious. So a sign over the door saying no Native people allowed here would be an example of direct discrimination, right? We're obviously excluding and singling out and treating differently a whole group of people. Direct discrimination is the most obvious kind, for sure. And it happens a lot. People are treated badly, treated differently, specifically because of a characteristic they may have. But a trickier kind of discrimination to recognize, and one that I think kind of flies under the radar a little bit, it doesn't smack us across the face in the same way direct discrimination does, is what we call indirect discrimination. And sometimes, especially in legal cases, it's called adverse effect discrimination. And this is the kind of discrimination I think it's so important for us to really understand better, because it can be really subtle. It can be really hard to spot, because it can often look like everyone's being treated the same. And if everyone's being treated the same, some people say, well, how can it be discriminatory? We're applying a neutral rule, a neutral policy, and it applies to everyone. So how could it possibly treat anyone differently or badly? We're treating everyone the same. I'll give you an example of a real case that was the very first case in Canada, at least that I'm aware of, where the court had to kind of think this through and decide, well, is it discrimination if they're treating everyone the same? And the example is this. It involved a woman named Ms. O'Malley, Mrs. O'Malley probably, and Sears, Simpson Sears as it was called in the 80s when this case happened. And Mrs. O'Malley worked at Sears, and her religion was Seventh-day Adventist. And Seventh-day Adventists, for those of you that don't know, their Sabbath day, their sort of holy day, is Saturday. And on the Sabbath, people who practice Seventh-day Adventist faith, they don't work. They're not allowed to work. The rules of their religion say you cannot work on Saturdays. So Mrs. O'Malley told her employer, Sears, I can't work on Saturdays. But the employer had a rule that said everyone needs to be available to work every day of the week. Not that they actually had worked 7 days a week, but they had to be available, to be scheduled. The employer wanted to be able to decide when people worked without people saying, I need Sunday off, I need Saturday off, I need Wednesdays off. His rule, the employer's rule was everybody has to be able to work every day. And the employer's defense was, well, this rule applies to everyone. I'm not singling out Seventh-day Adventists. I don't have a rule, I don't have a company policy that says no Seventh-day Adventists are allowed to work here. I have a neutral rule that applies to everyone, so how can you say I'm discriminating? But Mrs. O'Malley's point was, but I can't work on Saturdays. I can't follow your rule, and it has a negative effect on me. She ultimately was told that she just couldn't work at Sears anymore. And the negative effect on me because of my religion. When this rule intersects with my religion, there's a problem, and I experience discrimination. And the court agreed. The court said, you're right, Mrs. O'Malley, that is discrimination. Even though this is a neutral rule that applies to everyone, the effect on you is discriminatory. You're denied the ability to work on the basis of equality with others because of your religion and the way that it intersects with this rule. And so what the court said was, sorry, Simpson Sears, but you have to accommodate Ms. O'Malley by allowing her to take Saturdays off or to be off on Saturdays. So that's, I think, a good example. It's kind of a classic example of adverse effect discrimination, where it's not the intention of the employer to discriminate. Certainly Simpson Sears didn't go out making their rule intending to discriminate against people from the Seventh-day Adventist faith. But intention, the court said, doesn't matter. We have to look at the effect, the impact. Who has protection under the Human Rights Code? And the basic answer is everyone. Everyone has protection under the Human Rights Code. It doesn't matter whether you work full-time or part-time. In fact, even unpaid interns and volunteers have protection under the Human Rights Code, even if they're not getting paid. It doesn't matter if you are a non-citizen, if you're here on a temporary work permit, even if you don't have official immigration status in Canada at all, you still have rights in your workplace and in your tenancy and in your access to services under the Human Rights Code. And it applies no matter where we are in our lives. It applies to kids, it applies to adults, it applies to the elderly, it applies to everyone. No matter what age they are, no matter what immigration status they are, and no matter what their work status is either. And I've mentioned a few times where we have these protections. So just to spell it out one more time, we have these protections in our jobs. And as we just saw in our unpaid internships and in our volunteer roles as well, those are considered close enough to jobs or close enough to employment that the code applies. We have protections in our homes, both as tenants when renting a home, as well as in trying to purchase a home. We're not to be discriminated against by a seller, for example, of a unit in a strata or a home. And we're protected in our access to services. And this, as you can probably imagine, is the biggest category, the biggest bucket that we have of human rights protection. Services is a pretty broad category, and a lot is included in there. We have the example of universities. The services that universities provide must be provided in a non-discriminatory way, as well as other schools. Elementary schools and high schools also have to act in a non-discriminatory way. And just as a side note, we've seen quite a lot of human rights complaints actually brought forward by kids, or often by parents on behalf of their kids, saying that the child's special needs are not being met, when the child's disabilities are not being accommodated in their school. That's a fairly common human rights complaint that we see both in our clinic and at the Human Rights Tribunal. Other things that are considered services under the Human Rights Code include businesses and stores. You have a right to go into a store and not experience discrimination. A community center, a hotel, accessing government services. Government services have to be provided without discrimination. So a really big category. The last two don't come up too often, but I just want to mention them. We are protected from discrimination by our unions or by professional associations. And also the code talks about discriminatory publications. Publications that expose people to hatred or contempt, or that otherwise illustrate a discriminatory intent on the person that published them. So things like hate speech, for example, may be contrary to the code. I'm not going to talk too much about those two grounds. In fact, most of the workshop content is really going to be focused right up at the top, discrimination in our jobs. But it is important to know that we have these protections in other parts of our lives too, especially because so many of us are tenants And of course, all of us every day are accessing different services out there in the world. So we have protections there. It is discriminatory to treat people differently or badly on the basis of this list of personal characteristics. So what are they? Well, the first four, race, color, ancestry, and place of origin, lots of overlap there. They relate to someone's ethnic background, their race, where they come from, the color of their skin, their place of origin. All of these things kind of relate to your ethnic identity. Your religion, like Ms. O'Malley and her Seventh-day Adventist religion, or Jewish faith, or any other faith. Marital status, who you're married to, or whether you're married at all. Family status, who's in your family. You can't be denied a job because the employer doesn't like your brother. You can't be denied an apartment because you're a single mother and have 2 kids. Those would be examples of family status. Physical or mental disability are protected characteristics or prohibited grounds of discrimination. We can't be treated differently or badly on the basis of a disability. And then we're going to have lots more to say about that ground in a moment, so we'll expand on that one shortly. We can't be treated differently or badly on the basis of our sex. And sex includes sexual harassment. I used that example before. Sexual harassment is sex discrimination, and people can use the Human Rights Tribunal complaint process if they are experiencing sexual harassment on the job. Sex discrimination might also relate to pregnancy discrimination. Something that really surprised me when I started doing human rights work at the Human Rights Clinic is to realize how many people find themselves out of a job a few weeks after telling their boss that they are pregnant. It happens quite a lot, and it's discriminatory and not okay. And it's important for people who might become pregnant to know that, as well as for employers to know that as well. Sexual orientation refers to whether someone is gay, straight, lesbian, bisexual, or some other orientation. And gender identity and gender expression relate to, gender identity relates to how someone perceives their own gender and sense of themselves, and gender expression is how they express that gender out to the world. So those 2 grounds, gender identity and gender expression, are the newest grounds of discrimination. Our laws are always changing, always adapting to changing circumstances and sort of societal norms. And those grounds came into our laws in, I believe, 2015 to give trans people in BC really clear protection from discrimination on the basis of their gender identity and gender expression. We're protected from discrimination on the basis of our political belief. We're not allowed to be fired because we like Justin Trudeau over Andrew Scheer, or because we support the Green Party as opposed to some other party. You can't be treated differently because of your political belief or your political affiliation. We're protected from discrimination on the basis of age. You're not allowed to be told that you have to retire when you reach a certain age. You're not allowed to say we're only going to hire 25-year-olds for this job in the clothing store. Those would be examples of things that could potentially be discriminatory on the basis of age. You'll note the little note there, age is defined as only 19 or over. So what that means is that it's not contrary to the code to draw lines based on age when people are under 19. And we do that all the time, right? We say you have to be a certain age to drive a car, or to buy alcohol, or go to certain movies. So younger people are not able to make human rights complaints and say that's discriminatory, that I can't get into that movie that I want to see. They can use all of the other grounds though, and as I mentioned, students in high school and elementary school have made complaints against their schools for failing to accommodate their disability. So all the other grounds apply to young people, they just can't make discrimination complaints based on age until they're 19. Lawful source of income is protected in the tenancy context, so a landlord is not allowed to deny you an apartment because you're on CPP or social assistance. And a criminal conviction is a protected characteristic as well. It's a prohibited ground of discrimination. You're not allowed to be denied a job or fired from a job because you have something on your criminal record, as long as that thing on your record is unrelated to the job that you're doing. So an example might be somebody working at a bank. If they had, let's say, a credit card fraud charge, they might be, the employer, the bank, might be justified in saying, that's related to this job, we're concerned about potential risk, we're not going to hire you. But if the conviction or the thing on their criminal record was, let's say, driving under the influence charge, that's probably unrelated to the job of a bank or working at a bank, and the person couldn't be denied the job on that basis. So those are our protected characteristics. And I wanted you to have the list, the full list, to think about and know about. And the bulk of the rest of the workshops is really, as I mentioned, going to focus on physical and mental disability. Disability is the most common ground of discrimination that we see in the complaints that both come to our clinic and that go to the tribunal, and the tribunal makes decisions on. About half of all of the complaints the tribunal receives relate to either physical or mental disability. It's by far the most common ground of discrimination that people complain about. And if you think back to the purposes of the code, I think it is because we're still not doing a great job achieving those purposes of eliminating persistent patterns of inequality for people with disabilities and removing barriers to participation in economic, social, and cultural life. We have work to do to build spaces and jobs and homes that are truly inclusive of people with disabilities, and I think that's why we still see so many complaints coming forward. So I wanted to just provide a little bit more detail about what these grounds mean under the Human Rights Code and how the tribunal understands what it means to make a complaint about disability. So talking about physical disability first of all, it's important to say that there's no list. There's no list of things, conditions that count as disabilities for the purposes of human rights law. There's no kind of closed box that says these things are in and these things are out. So it's sometimes an issue that has to get decided by the Human Rights Tribunal. Does this qualify as a disability or not? But what those cases tell us is that in order to know whether something will qualify as a disability under the Human Rights Code, we can ask a set of questions. And the first is whether it's an involuntary state, something that someone is dealing with. And the most important thing is it severe? Is it permanent? Or is it at least persistent in its impacts? And does it impair a person's ability to carry out the normal functions of everyday life? Does it get in the way of people doing their job or accessing services? Does it in combination with the way that societies are designed and built, create barriers for people to participate in their workplace or in other areas of life? So as I mentioned, it's a case-by-case assessment every time. There's no kind of guidance beyond that to ask. We ask, is there a degree of permanence or persistence to this condition or situation the person's dealing with, and is it getting in the way of their everyday life? So a couple of examples perhaps might help illustrate that. A cold, catching a cold. Gets in the way, for sure, but do you think it would qualify as a disability based on these criteria? You're shaking your head there, Spring. Why do you think no? It goes away, exactly. It doesn't have that degree of persistence or permanence that is required for something to qualify as a disability. All going well, you're gonna get over it in a week or so. Okay. What about a broken leg? Do you think that would qualify as a disability? I think it probably would. I mean, like a cold, you're gonna get over it eventually. You're gonna get a cast, it's gonna heal. But for that period of time, that's a pretty long period of time in most cases. Maybe if it's not such a severe break, it might be kind of on the borderline, but in most cases, you're gonna be in a cast for a while. And depending on the nature of your job, you may be really limited by that broken leg in what you can do. If you were, let's say, a stalker at a grocery store and you were responsible for walking up and down the aisles of the grocery store all day, reaching up onto high shelves and crouching down to put things away on low shelves, having a big cast on your legs is definitely going to get in the way of your ability to do that work. So I think that if your employer was not accommodating you while you had a broken leg and a cast on, you might have a human rights complaint on the basis of a physical disability. How about the next one? Mental disability, same idea. There's no list. These are the disabilities or these are the conditions or diagnoses that count or qualify as a mental disability, and these are the ones that don't. It's an open category and requires a case-by-case assessment. But again, the kind of essential question is, how does it affect a person's abilities? Is it persistent? Is it relatively severe? And is it getting in the way of their ability to do their job and sort of go about their daily life? So things like learning disorders have been held by the tribunal to be mental disabilities, developmental disabilities that a person may have or be born with, and mental illness as well is categorized within this this prohibited ground, this protected characteristic of a mental disability. So something like an anxiety disorder, depression, post-traumatic stress disorder, schizophrenia, bipolar, these kinds of mental illnesses would be examples of disabilities that, again, may require an employer to accommodate them. And we'll talk about accommodations very shortly. Also, just want to flag that the issue of addiction is a disability as well. We understand and acknowledge these days that disabilities are involuntary. They're medical conditions and situations that people are dealing with and need to be approached in a kind of from a medical and health perspective kind of way. So employers may have obligations to accommodate and support people with addiction issues as well, because they are disabilities too. Alcoholism, or any kind of drug addiction problem, being addicted to opiates or painkillers could be an addiction issue. Cigarettes is a tough one. There's case law going both ways, saying that yes, it is a disability. And smoking cases often give rise to kind of the quintessential human rights issues, which are how we balance competing rights. So we see cases sometimes where there's a group of neighbors living together in a strata, and one person in one unit smokes, and the person in the next unit has a lung problem, breathing problems, asthma, disability. And this person claims, well, they have a disability of addiction to smoking, and this person has a disability of, your smoking is making my asthma worse. And the Human Rights Tribunal sometimes has to balance those competing claims. So it can get tricky, and it's not easy necessarily to do that balancing, but the goal always is, how do we accommodate people to the best of our ability? How do we try to find a balance where everyone's rights are supported and accommodated as far as possible? But that as far as possible, and you brought up the limits in the charter, rights are never absolute, right? And we'll talk a bit more about that balancing throughout the workshops, actually. I also just wanted to introduce this term if it's not familiar to you, or just name it if it is familiar to you, because it's an important one. I've talked about these protected characteristics kind of one by one. And I don't want to give the impression that discrimination happens just based on one characteristic at a time. We, of course, aren't just one thing at a time. We are all of our things all at the same time. And so it's important to remember that these different grounds of discrimination sometimes lay on top of each other and intersect and overlap to create additional vulnerabilities. A woman with a disability and a man with a disability might experience their disability really different because there is gender on top of that and the potential for gender-based discrimination. A person of color with a disability and a white person with a disability might experience the world really differently because of the intersection of their race and their disability together, right? We have to remember just the ways that people are complex and the systemic forces that are impacting us in the world, those barriers and biases and stereotypes, they're coming at us from all sides. So that's important. Let's talk a bit about who may be responsible for discrimination, who may fall on that respondent side of the equation. If you recall, I told you that the person who makes a human rights complaint is called the complainant, but the person or business or organization the complaint is about is called the respondent. So examples of potential respondents might be employers, companies, businesses, service providers, landlords, business owners, unions, manager of a business, service provider. All of these are potential respondents in a human rights complaint. And sometimes people wonder, well, the person who terminated my job, for example, when I told them that I got pregnant, they're the ones that did the discriminating. And sometimes that's true, but it's generally the employer, the business, that is responsible for maintaining a discrimination-free workplace and is responsible for any discrimination that may happen. So employers have a duty to provide a discrimination-free workplace and may be liable for discrimination that's happening in the workplace when it's going on under their noses and they're not taking any action to address it.
One interesting point I'll just jump in and add here is, and sometimes it's a surprise to people, is that employers don't necessarily need to know about the discrimination. So when you say it's happening under their noses and they're not doing anything about it, sometimes the company doesn't even know that it's happening. It's a manager or a coworker who is behaving in a way even that the company wouldn't support if they knew, but the company is still responsible whether they know or not about what's going on.
I often say the buck stops with the employer. It really is their ultimate responsibility to make sure that they're providing a safe and inclusive and discrimination-free workplace. And that example that I gave a moment ago where, let's say you told your boss that you were pregnant, and a couple days later your direct supervisor called you up and said, you know what, we don't need you to come in today, and in fact you're going to be terminated. That direct supervisor wouldn't be responsible for the discrimination. Even though the termination might be discriminatory, that supervisor who called you up and was the messenger for that is not the person that would be responsible for the discrimination. It would be the employer who made that decision. So an employee that's acting within the scope of their employment duties, like a supervisor, is not responsible for discrimination. However, an employee that is acting outside of their employment duties could be individually responsible for discrimination along with the employer. The employer is ultimately responsible, buck stops with them, But if there's an individual who is harassing other coworkers, that's not part of the job description. That's not part of what they're there to do. It's not part of their job duties. They are acting way outside of what they're supposed to be doing on the job. And in situations like that, that individual could also be liable and could be named as a respondent in a human rights complaint.
So this slide describes in a human rights case what each side has to prove. So if you are a complainant, that means you're the person who is saying, I was discriminated against. To be able to move forward with a complaint of discrimination, you have to prove these three things that are laid out on this slide. So you have to prove you have a protected characteristic, and that's the list of the grounds that are protected under the code, which I'm assuming you already went through. So age, gender, physical disability, mental disability, religion, any of those protected characteristics. You have to prove that you were treated negatively. Just to keep using the same example that Laura was using, pregnancy is a protected ground as an aspect of sex because only women can get pregnant. And getting fired is a negative treatment. So those two things are established, and those two are usually the easier things to establish. There sometimes is a question, for instance, how do we define disability? Does what your characteristic is meet that definition? But usually those pieces are pretty straightforward. The tricky one is the third, which is the connection between the characteristic and the negative impact. So you could be pregnant and be fired, and there could be no relationship between those two things. I use the example, and if we're talking about disability, just to mix it up a bit, you have a disability and you were fired. Well, if the company closed and everyone was fired, whether you had a disability or were able-bodied, who thinks that would be discrimination? If the whole company closes and everyone is fired? Nobody, right? So that's a situation where you have a protected characteristic. We all have protected characteristics of some kind, and we all have bad things happen to us at work sometimes, but it's proving that, we call that the nexus, that's the connection between the two. And that can be very difficult. I represent companies as well as individuals in my work. I'm a lawyer as well. I'm sorry you've got two of us. That seems cruel on a Friday afternoon. But that's always the question I'm getting down to is how, if I'm working for a complaint and an individual, how do you know that your protected characteristic was connected to the decision? Because usually people don't outright tell you, right? Most companies now and individuals are smart enough to say, well, I'm not going to say that your religion is the reason I'm firing you. I'm going to come up with another reason or not give you a reason at all. And so sometimes we have to look at the surrounding circumstances. If sometimes they'll say it's a layoff, but if it only impacted women and not men, then we're going to look at that and see if there's some way we can prove it without actually having someone admit it, because rarely, like I said, do people admit it. So if you're the complainant, those are your three things you have to prove. If you're the respondent, so when I'm acting for companies and someone is saying, I feel I was discriminated against, these are the things that we look at. So we say, was the treatment justified, and is there a reasonable explanation? So the example I gave of the company closed, everyone got fired. That's a justified, reasonable explanation that has nothing to do with the protected ground. Another, I would say the most common thing that comes up in my experience in this is performance, right? So if you were not doing well at your job, that is a reason that someone can let you go. And sometimes that's related to a protected characteristic, sometimes it's not. so that when you're looking at the company's case, they have to really be able to prove, if they're gonna say, I know this looks like discrimination because we fired all the women, but really the women aren't performing as well. Well, you're gonna have to prove that, and probably have some documented evidence to back that up. Is that a question or is this a stretch?
Question about what if employees are on probation?
Yeah, so probation is irrelevant if we're talking about discrimination. So just like employment discrimination even applies before you get a job, like when you apply for a job. If you're not considered or not hired because of a protected characteristic, that can be discrimination. Doesn't matter if you didn't work there one day. So whether it's your first day of work, and you show up and they say, oh, you know, I didn't know that you had a disability, so now I'm going to let you go. Or whether it's 5 years in and maybe you've had an accident and now you have a disability that you didn't used to have, it doesn't matter the length of time at all. And it doesn't matter whether you're in the probationary period or not. Everyone's human rights are separate from employment standards and contractual rights. They override everything else. Yes, question?
When did the pregnancy one come in?
Pregnancy, well, sex has been listed in the Human Rights Code for a very long time, certainly as long as I've been practicing law, which is 2004. There was a very famous case called Brooks and Safeway, and that was the decision of our Supreme Court of Canada, which is like the Supreme Court of all courts in our country, where they said that pregnancy is part of sex because only women can get pregnant.
Well, no, it's because my aunt was employed by the Canadian military. Back in the early 80s, they turned, when she got pregnant, they turned and told her, have an abortion or lose your job.
Yeah.
It was
Well,
that straight.
There was a point in time where pregnancy was not protected and women lost their jobs all the time when they became pregnant, and that was legal. And that's one of the reasons why the law came into place, was because we, as society, we need people to reproduce, and so that we can keep going as a society. And guess what? Only women can do that. And so if we all get fired when we get pregnant, I mean, I would have been fired 3 times, I guess. I probably wouldn't be standing here today. I probably wouldn't be practicing law anymore. So those are the first 2 under the respondent's case, and the last one is bona fide occupational requirement. I always get really annoyed when Latin is in things.
I just have a question
Yeah.
before you go on.
Yeah.
Harvey said that, like, a person can be liable for discrimination even before the job gets started.
Mm-hmm.
So does that qualify for, like, the interview process, and, like, you're more than qualified for a job? And I guess my question is there any way to prove, like, if the employer decides, oh, I'm not going to hire you right away, and you think, oh, it's because I'm in a wheelchair, like, is there any way that you can prove that and bring it to the tribunal? And
Right. So I guess, back up a few practical steps here, okay? Because we're on the left side here. We're talking about the complainant's case.
yes.
So you have a protected characteristic, you have a disability, that means you're in a wheelchair. So that's linked to your protected ground, okay? There. Negative treatment, you didn't get hired, okay? So we've got the first 2. We're in the third of how do we demonstrate that there's a connection between the 2. And you're right in that can be incredibly hard to do, and it's not enough to say, I think it's because I was in a wheelchair. There has to be you have to have some kind of connection, whether it was a comment that was made, whether you happen to know who got hired and you know they weren't as qualified as you were. Those would be the kinds of parameters. You can start a complaint. You can file a complaint with the Human Rights Tribunal. It is very easy to do. You fill out a form. I think we're going to go through that in one of the sessions. And when you file the complaint isn't when you have to prove it. So that's why I'm just being really specific about your question. Like, is that if you feel that you didn't get hired because you're in a wheelchair, could you file a human rights complaint? You could. Would they accept it? You would have to have some kind of connection. So you would have to say something or put in something that demonstrated some kind of connection. For instance, I know the person they hired wasn't as qualified as me. That would be a connection or a potential connection. Question, yeah.
What about if we, like, say, like the job posting or something contains like something that is discriminatory? Like, example, we were just looking at job postings, and it was like must have verbal English skills despite like all like if they're qualified or not. You must be able to speak is written in it, but that just completely discriminates like against all like non-oral people, deaf individuals, and various other groups of people despite all their other qualifications. So like even if you didn't make it to like an interview process because they had this, does it still count as discrimination?
I believe you can file a complaint about a discriminatory job posting.
Yeah.
Laura's probably seen this more than I have, but I believe you can. And there's a very famous case called Majoran. Have you talked about that one
We
already?
have not.
And Majoran, it's one of my favorite cases to talk about, and I'm such a nerdy lawyer, I'm sorry. But it was a case, Tammy Majoran was a forest firefighter. And it was about, I like the nods, there's more of my people in the back that love cases. Yeah, for sure, sorry. Yeah, no, I move around a lot. I've been sitting too long, so. So Tammy Majoran was a forest firefighter, and there was physical testing that was required for the job, and you had to be able to do, I can't remember what the things were, but it was like running, carrying things, it was physical testing, okay? And her complaint was women generally are going to get weeded out by this testing more than men, so it's discriminatory, and the employer couldn't demonstrate that what they were asking her to do was actually related to what she needed to do in the job. Okay, a bona fide, it's a true requirement of the job, and it does cause discrimination, but it's justified in that case. That's a very high standard, and it could be like when I hear that job posting, to me, I think that is probably coming from a place of lack of knowledge.
Yeah, so like,
Right? Like that, I don't-
devices and stuff. But if
Right.
there is like assisted devices and like they are available, then does that make it non-bona fide? Like that
Well, accommodation, we're going to talk a lot about this in the sessions to come, is a two-way street. And so both parties have to provide suggestions and be open, and part of that is education and information. There's, employees and running a business doesn't come with a handbook that says, here's how human rights works. And so there are people running businesses who genuinely don't know. But like, I'm thinking of your job, and your example, I think is a really good one. Like if it was a job, for instance, that didn't require speaking at all, like maybe you're doing some kind of paperwork job where you don't actually have to speak, or speaking is very peripheral and just happens once in a while. That there would be no reason why that should be in a job posting as a requirement.
also said like specific English too, so it leaves out people that don't speak English as well, like people from other countries or like different ethnicities. So it kind of is pretty, the job did not require that.
Yeah, it's all about, does the job actually